Good morning, afternoon, or evening. I am Stephanie Joy with All Things Social Security and the attorney at Joy Disability. You're about to see what should be a question and answer format type of chat from our live session on a particular topic that we find that a lot of people keep asking about. So I'm sharing it here. If there are pieces that could have been added that weren't added during the live, because it's a kind of a fast-paced Q&A that we do every Wednesday at 1 p.m. You might just find that I added something to the end of it to give it a little more clarity and a little more details for those that are interested in that particular topic. So check to see if that's at the end. Otherwise, enjoy the video. Bye-bye.
Mr. P, do you know if you can win a case for SSDI if you keep going over SGA due to understaffing and callouts? I'm on reconsideration. Will they look at my week hours, or is that SSA, not DDS? Yeah, they all look at that because the DDS is doing the adjudication, and the sequential evaluation process, the first question is he doing SGA? If you are on and off SGA, assuming it hasn't been enough to put you into your, what would be retroactively your 3-year EPA, extended period of eligibility, where you'd have months not due you, and then if it's after the 3 years, the first month of SGA means ding, 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 not disabled. The thing is, you're doing over SGA, you're able to do over SGA whenever there's understaffing or callouts. It suggests optically that you could do SGA. If I were you, I'd be very clear. I mean, if you can, that I cannot do more hours in this, period, end of story. No, I cannot pick up other shifts, because you are going to, if you don't screw yourself now, you will screw yourself if you win. You will lose it. You will also get overpayments, probably, and have some debt, and then lose them altogether in time. So sometimes you have to, put on the big boy pants and say to the boss, listen, I can't do this. You don't have to tell them why. Just say, I have other obligations. I can't pick up these cases. I can't do that. Or, or whatever it is. I don't know how you would say it, but because I think if you keep doing it, yes, it's going to, it depends on how much you're doing it, but eventually any of it is going to, any continuing, even if it's sporadic, SGA will eventually get you to lose your benefits if you win them at all. All right. Willie says, darn, missed your responses because I had a telehealth call. I'll look back when this is live. Oh, that's so funny. I felt like I was talking to you when I was answering them, but you weren't even here. All right, guys, we are at an hour and a half. Hi, Deanna. Good to see you. Mr. P says, I don't mind is, got to see the end of that. There are no questions after that, guys, though. Like I said, we are kind of slim today. I didn't create this live stream till right before I did it because I thought it was already set up. Yeah. It's been like that. YouTube is taking a little bit of a hit with the busyness around here, but that is easing up slowly but surely, and which is really cool. So anyway, all right. So I don't see any more questions. If anyone has anything they want to share, any kind of questions, I am happy to answer them now. Otherwise, we're going to say adieu, and I hope to see you guys next week. Right? I'm here. Yep, next week, 1 p.m. Eastern Standard Time. I will get that thumbnail up there under the lives coming up. The live streams coming up. Usually I like to have 4 ahead of me, but that 4 weeks just flies. I had 4. I'm like, what happened to them? I went through them all. I guess so. And then, of course, if you turn on the 12 p.m.s, usually 12 p.m., daily pre-recorded, that is super helpful, guys. It really supports the channel and the mission, which is, as you know, the 1%, 5% crowd. Memberships, of course, also help. But anyway, and for those of you that don't know, and this would be probably the small minority of people that would even do a consultation, membership gets you membership at the top tier, which is like the dedicated or something like that. I believe you get like 2/3 after you've been a member for, I think, at least 2 months. If you need a consultation, you get 2/3 of the price off of the normal one. 2/3 off. I think it's about 2/3 off. So it can be a little bit of money saving anyway, because I know they're not cheap. But since they're not what I'm in here to do business for per se, it's really representing clients as their appointed attorney representative. That's how we do that, so we can do it all and not do. It also helps with the pro bono work too, affording that. So anyway, hope you guys all have a great one. I hope we have good weather coming up everywhere in the country. Hope everyone's doing super well.
Good morning. SGA. It's such a common question, and it is so very important for Social Security Disability or SSI. I'm going to try to just give you some overall really fast. You get a kind of a broad understanding of why this is important. In the sequential evaluation process, when the SSA decides if you are disabled and when, the first question they have to answer is the person working SGA now? Okay. At other times, they will look to see if you were doing SGA in the past, but it always has to do with if we are doing it during a period of alleged disability or it was a period of disability in the past. Okay, substantial gainful activity. That is what SGA stands for. I'm going to also read you a little bit from the Social Security narrative here, so you can take a listen. And I will make sure that this there'll be a button at the end that has this exact page, so you can click on it and read this for yourself, because I know sometimes it's not so easy to absorb while you're just listening. So in this particular section, they are introducing the issue of work performed during a period of alleged inability to engage in substantial gainful activity, SGA, substantial gainful activity. Okay, it concerns work performed by a claimant filing for benefits or by an individual already entitled to benefits. That's what I alluded to before. And they go into two different things here. Substantial gainful activity means the performance of significant physical or mental activities in work for pay or profit, or in work of the type generally performed for pay or profit. So even if you're doing something voluntary and not getting paid, it can still be considered substantial gainful activity, regardless of the legality of the work. Thus, if you are doing something like dealing drugs and making money, that will still potentially count as SGA, even though dealing drugs might be illegal. Okay. Or if you're, I'm making stuff up here, prostituting yourself, is it SGA? I mean, you could think of all the different kind of illegal things that can be certainly substantial and gainful. Now they give you a definition or a narrative with regard to the term significant activities. Significant activities are useful in the accomplishment of a job or the operation of a business and have economic value. Work may be substantial even if it is performed on a part-time basis, or even if the individual does less, is paid less, or has less responsibility than in previous work. So merely dropping down in duties at work does not necessarily put you under SGA. Work activity is gainful if it is the kind of work usually done for pay, whether it's paid in cash or in kind. Now remember, in kind could be anything other than cash. It can be clothing, it could be perks, it can be food, it can be shelter, or for profit, whether or not a profit is realized. Activities involving self-care, household tasks, unpaid painting, unpaid training, hobbies, therapy, school attendance, clubs, social programs, etc., are not considered to be SGA. Now, those things can be considered to determine whether someone is disabled or not, but they're not going to be used to determine if someone is doing work activity that if they were paid to do it, they would be earning over SGA or showing that they were doing SGA activity. Okay, so SGA, it's an activity review, as kind of described here. There's also a black and white amount of money that if we earn it and we don't have deductions from it, that would bring us to a lower amount. It can be also a kind of like a black and white finding of SGA without even looking at the activity. So SGA in 2023 was $1,470. SGA in 2024 is now $1,550. So if you hit those numbers, you would be deemed to be doing substantial gainful activity if that activity paid that amount. So that's kind of like the black and white. And again, if you hit the number, always look to some of the exceptions where certain amounts of that earnings can be deducted that could bring you below SGA. If SGA is otherwise going to, prevent you from filing or cause you a termination later. SGA, it's what we're doing, and it has to do with whether we are disabled or not under the rules. If we earn too much, we are not eligible for disability under the rules. And it's definitely an inquiry that takes a little more analysis, because sometimes brief periods of earning SGA or doing activity that would be deemed SGA can be argued to have been a failed work attempt. Okay, so it's not necessarily cut and dry. It is or it isn't. It really depends on a lot of questions. So if you're dealing with a question of SGA and you're concerned about it, you probably want to get a consultation on it or do a lot of reading, because it can make or break a current case or create a potential cessation of benefits later. Okay, SGA. By and large, when we first analyze a case as to whether or not we're going to take it, that's one of the questions I ask on my initial interview. Is what kind of work, when was it last done, how much? Because the question of SGA is going to go towards your application. There is a question, and I'll bring it up because on our format, we ask it when we gather our data. And it says, when do you believe your conditions became severe enough to keep you from working, even if you have never worked? And this answer would typically not be before you stopped earning more than SGA. It would usually be at the time you stopped earning SGA amounts or after. Now, that is not 100% all the time, but that's generally how it is. And the reason why they ask, when do you believe your condition might have? So let's say you're earning SGA, but you believe a year before you stopped working SGA, you went part-time, you stopped altogether, but a year before that, you feel like you were not able to keep working, although you still were. There is some remote instances where if we can prove that the work you were doing, and this would be by assistance from the employer confirming this by and large, if the work you were doing and getting paid above SGA for was actually not worth SGA and they were just kind of subsidizing you and being really nice, that could potentially come in there. By and large, though, that's a battle that unless you already have an employer willing to say you weren't working the amount they were paying you, they were kind of gifting you the other amount, this isn't going to bring you very far. So you could be spinning your wheels. So for us to consider it, the person has to have the goods in hand. Go get the letter from the employer saying how you were not earning your keep, but they were just kind of being nice to you. All right, SGA, substantial gainful activity. It's important when you apply. It is important all through your pending claim, very important for those that are working part-time, which is not necessarily a problem, but these are things that have to be addressed, and you need to talk about it with your representative and make sure you're not inadvertently putting yourself in danger. And it is also relevant after you stop, after your pending claim stops, you have prevailed, and now you are a beneficiary. If you are working part-time, this is uber critical, okay? You definitely want to have a fine analysis with it and make sure everything is working where it should and is not putting you in danger. Okay, SGA, substantial gainful activity. Talk to you later, guys.